Hello friends, in the series on the income tax cases, today we will discuss the case of Rajinder Kumar versus State and Another. This case has been reported in 451 ITR at page number 338. The matter has been decided by Delhi High Court and the date of the judgment is 16th December 2022. This case is regarding the prosecution launched against the assessee. The facts of the case are very interesting, and this case gives a message that if anything which is contrary to the law has been done by the assessee, then the action against the assessee can be taken even after 20 or 30 years after. This is the perfect example of this thing, and an assessee is always at the peril of the various fiscal laws, because the fiscal laws are so complex, and even the assessee or sometimes even the professional do not know about the total compliance which is to be taken by an assessee. In this case, the assessee opened a bank account in 1991 in London. After 20 years, the department received the information from the country France that the assessee has opened a bank account in London. And due to this information, a search was conducted on the assessee in 2011, 20 years after when the bank account has been opened by the assessee. When this search was initiated, the notice under section 153A and then section 142 subsection 1 were issued. But the assessee didn't comply with these notices, due to which the penalty under section 271 was also initiated against the assessee. The prosecution notice under section 276C subsection 1 read with section 279 were also issued to the assessee, and the assessee also deposited all the taxes, interest and penalties. When this bank account was opened by the assessee in London, at that particular time, the age of the assessee was 55 years. But when the prosecution was launched against the assessee, then obviously the assessee was more than 70 years of age. When this prosecution was initiated against the assessee moved to the High Court for taking the benefit of instruction of 1991, instruction number 5051, and it was the plea of the assessee that my age is more than 70 years. So according to this instruction, the prosecution cannot be launched against me. On this, the court said that the instruction says that the age of the assessee is to be seen at the time of the offence and not at the time of the initiation of the prosecution by the department. The facts were very clear that the age of the assessee was 55 years at the time of commission of the offence. So the instruction number 5051 dated 7th February 1991 was not applicable to the assessee, and whatever the prosecution has been launched by the department against the assessee, that is within four corners of law, and the prosecution cannot be dropped on this ground that the age of the assessee is more than 70 years. Friends, see the procedure of the law and see the timeliness of the law, that an assessee who has opened a bank account in 1991, even then a prosecution against the assessee can be launched after 2011, and now the year 2023 is going on, and the verdict of the court comes that the prosecution is justified. So it means that for an offence which is done before 30 years is now being decided by the courts. So the fiscal laws are like that. The assessee has to be very vigilant, very cautious about complying the laws, and especially in cases where you have made investment outside India. But nowadays a lot of notices are coming in which the assessees has purchased the properties, but the returns have not been filed, or the returns have been filed at a very low figure. So all those cases are under the radar of the income tax department. At the end of this video, once again I am repeating the name of the case. The name of the case is RAJINDER Kumar versus State and another, and this case has been reported in 451 ITR at page number 338. The matter has been decided by Delhi High Court and the date of the judgment is 16th December 2022. Thank you, friends.